everybody. Welcome back to the revived International Economic Law Collective Conversations. We've missed all of you and we've missed chatting to each other about contemporary issues. We started this series last year in 2020 when the pandemic first hit, to really just have a conversation between scholars and practitioners of international economic law on the impacts of the COVID-19 pandemic on various issues relating to the law and policy governing the global economy. And it was a way of us trying to also make sense of our place and the evolving circumstances. So we're very pleased today to return to our conversations a year and a bit on from the declaration of the outbreak of the pandemic. And it's still with us. In fact, we're seeing quite serious outbreaks in the global south, particularly in India and the Indian subcontinent, and in parts of Asia where cases at the moment, and it's May 12, 2021, have been really increasing quite rapidly. So today we're going to talk about one of the pressing issues relating to the global response to the pandemic and global health, which is the issue of vaccination. And one of the success stories and the story of failure of this global pandemic, I'm sure the speakers here today will agree with me, is this rapid acceleration and rapid development of vaccines, which is quite amazing and astounding, but has also demonstrated the asymmetries and the inequalities in the global economy and the international economic rules and institutions that govern the global economy. So today we're going to talk about vaccines, we're going to talk about patents, and we're going to talk about trade law, we're going to talk about trade law institutions, and we're just going to have a rant about things. Right, so joining me today are our IEL Collective comrades, Tara Van Ho from the School of Law at Essex, and Tara works on business and human rights. We have Sharifah Sekalala from the School of Law at the University of Warwick, and Sharifah works on the governance of global health. We also, joining us today is Annamaria Vanni from the School of Law in Leeds. And Annamaria also works on intellectual property and global health and other related IPR issues. And we have Annamaria La Chimia from the School of Law at the University of Nottingham, and Anna works on issues relating to trade law and public procurement. And I forgot to introduce myself. I'm Celine Tan, I'm from the School of Law, and I work on international economic law and development with a focus on development finance. So, I'm just going to give the kind of floor to Annamaria and Anna to kind of give us an overview of what's the debates are at present in relation to global health and patents and vaccines and the pandemic. Annamaria?
Okay, so right now, as we all know, the COVID pandemic is ravaging the world, and October last year, 2 countries in the global south, India and Brazil, put forward a request at the WTO for the organization to waive any IP-related rights with regards to COVID vaccine, therapeutics, and diagnostics. But before we get into the waiver, we basically have to talk about what is TRIPS agreement, and why is a TRIPS waiver needed. So TRIPS agreement is the global, or it's the full name is the trade related aspects of intellectual property rights. So it's the global agreement dealing with issues of intellectual property. So we're talking about copyright, we're talking about trademarks, geographical indications, patent, the protection of undisclosed information, all those exciting things, all those exciting intellectual property issues. TRIPS provides a global minimum standard on what to protect with regards to intellectual property. So by global minimum standards, I mean the level of protection or rights accorded within the TRIPS agreement is the baseline anybody or WTO members must apply. So for instance, TRIPS provides 20 years protection for patent rights, and this covers both production and the process, right? So manufacture, technological product and technological process. So this means you have to provide patent rights. Let's take pharmaceuticals, for example. You have to provide patents or IP rights for a drug, like the whole tablet, the medicine, the shape of the tablet. You have to, the color of the syrup. You have to provide patent for it, but you also have to provide IP protection for the process. So the process of making that particular tablet or drugs or diagnostics. So every single thing is covered under the TRIPS agreement. And of course, the protection in TRIPS is not absolute, right? There are exceptions which countries would have to, that countries can utilize to protect their citizens. These are known as the TRIPS flexibility. So this includes compulsory license, which is when a third party is allowed to make use of IP protected products or processes. You have parallel importation, you have BLA exemption, where you can use IP protected products or process for research purposes. So TRIPS covers all these things to make sure that IP right does not impinge in any form of human rights or rights of various countries to protect their citizens. So this then leads us back now to COVID situation. As per TRIPS agreement, any form of diagnostics, tablets, vaccine, injection tablets, whatever it is with regards to treating COVID is protected under intellectual property rights. So one of the things Brazil and India requested was that during this whole pandemic, right, any IP related any COVID-related products should not be given IP protections to allow for vast use to protect to protect lives, and also to make sure that we'll come out of this pandemic as quickly as possible. It's also important to note that this particular request doesn't mean that from now till forever, all TRIPS or all COVID-related treatment, diagnostics, therapeutics should not have IP protection. This waiver is actually temporary, and Brazil and India in their request stated that until we are out of the pandemic or until the world develops herd immunity, then the waiver, then after that, the IP protections can come back into play. And most of the things I've been reading in regards to the TRIPS waiver was, okay, so when do we know the pandemic is over? Just as we knew from March 9, 2020, the World Health Organization announced that we are in a global pandemic. Once the threat or the seriousness of the pandemic is under control, the WHO will also announce that we are out of the pandemic. So this is one of the ways to know when, so how to know the durability or the duration of the TRIPS waiver. One of the things I also like to point out is, as the world delays or dilly-dallies with regards to granting this waiver, we are extending the pandemic, right? So it's actually in our global interest to make sure that the TRIPS waiver comes into play as soon as possible in order to help ramp up production of COVID-related treatments and diagnostics and therapeutics. That will make sure that will lead to more people getting vaccinated, and also that will lead to the quicker we deal with this pandemic and the more herd immunity the world develops. One last thing in regards to this is so what is the importance of the TRIPS waiver? One of the things the TRIPS waiver hopefully or the aims to do is to make sure that generic companies in different parts of the world can access the related IP protected technologies or information to help in the ramp up of production of COVID-related treatments, right? And also, it's not like the TRIPS waiver is the magic bullet that once the TRIPS waiver comes into play, automatically we found a solution to the active issue of access to COVID medicines. That is not the case. The TRIPS waiver is just one strategy out of a multi-pronged strategy with regards to making sure that we have COVID vaccines for everybody around the world. So in addition to TRIPS waiver, we're going to know the transfer of technology, which we're going to talk about much later in this conversation. We are also going to need sharing of knowledge, know-how. Of course, we're going to talk about this. And also we're going to need funds to make sure that generic pharmaceutical companies who can have the money provided by various state governments or even by a global body to ensure the ramp up of production of COVID-related vaccines, technology, and diagnostics.
That's great. Thanks, Amaka. I just wanted to just, maybe prod you a little bit on that. I mean, obviously the it's about a negotiation that's happening now within the World Trade Organization, the WTO, the TRIPS agreement being one of the multiple trade agreements within the WTO, right? And just so that our audience is sort of like very clear about, like the impact of TRIPS, the WTO has this sort of like idea of principle, and Anna can come in on this about cross retaliatory action. That's why TRIPS is so strong as a international trade agreement, right? That if countries or member states of the WTO are in breach of the TRIPS, they could potentially, other member states could potentially take retaliatory action under any of the other WTO trade agreements, such as the general agreement on tariffs and trade, and general agreement on trade in services, and agreement on agriculture, and all the others. So just put it out there. Am I correct, Anna and Amaka, right?
Yeah, maybe Anna, do you want to take this?
Yeah, sure, and absolutely, Celine. I think you've touched upon a very important point. The TRIPS agreement has been so successful because member states have been able to use the dispute settlement system within the WTO, and because they've managed to they've taken strong retaliatory action against countries that did not implement the TRIPS agreement. And in particular, we've had the US that has been very forceful in monitoring whether developing countries were implementing the TRIPS agreement. But even more so, the US has used its bilateral trade negotiating power to make developing countries agree TRIPS plus provisions, so provisions that are even stricter than those provided for in the TRIPS agreement. And this is something that we shall not forget, because this is how the TRIPS agreement has become so effective, even more than any other agreement that we have within the WTO. Think, for instance, the agreement on agriculture, that is barely ever enforced. But also, I would say that maybe even in light of this and the history of the TRIPS agreement, the history of the use of compulsory license that has always seen the US against the use of compulsory licensing, especially when it was the case of HIV/AIDS against Brazil and South Africa, that, as we know, has really retaliated against the US. Its position of being has backfired, the position of being against the use of compulsory license in that instance, and is what triggered the Doha Declaration, is what triggered the mechanism of the waiver, which in the end has also been used by the US within the internal market to get the prices of HIV/AIDS retroviral drugs decrease. But, you know, even for this reason, I would say probably the fact that the US is now supporting the waiver is so important. And I think, you know, many people we've seen sometimes on Twitter saying, oh, everybody is going crazy for this support by the US, but it doesn't mean much. The waiver won't have much effect. And we will come back to this. We will say why, to many extent, this is true. Because it's an issue of production more than anything else, and of know-how and so forth. But it's important from a political standpoint. It's important for what it means and for what it represents, that the US, who has been in alliance with Big Pharma, and funny enough with Pfizer in the 80s for the agreement to be adopted, to now support a waiver. Support, however, that substantially puts into question the very existence of the TRIPS agreement, as you know, a fantastic blog by Ann Orford, by Professor Orford, has stated. You know, do we really need the TRIPS agreement in the first place? Shouldn't we reconsider whether we need the TRIPS agreement? So, you know, from that point of view, Celine, you were absolutely right. You know, this is how we managed to have not only the TRIPS, but even using other trade mechanisms. We've had the TRIPS Plus be endorsed by developing countries, even in situations where, you know, how it has also been abused, the system of patent protection, also by the fact that many developing countries didn't have the capacity to really understand if what they were granting a patent for was actually innovative, which is one of the requirements of the TRIPS agreement. So, you know, how much abuse there has been from that point of view, how much appropriation of traditional knowledge there has been from pharmaceutical companies when patents were granted in developing countries. This is something that, you know, it's often not discussed by mainstream trade lawyers. You know, and it's really something important that I think we need to reflect upon when looking at the TRIPS and how we can reform it, or you know, scrap it all together and start something new. But before we move on, I just wanted really to say a couple of things about the TRIPS agreement. I mean, already Amaka is given a brilliant outline within the 5 minutes available on what the TRIPS agreement is and what the implications are. But just I want us for a second to reflect on the fact how really Big Pharma has managed to change the wording, the language that was used, from one of IP as a grant of privilege to one of IP as a grant of property rights. You know, the property rights that are so important in a country, especially like the US. The fact that IP protection was seen as a fundamental step for a healthy trading system, as a fundamental step for free trade and for investment. And you know how we have worked the agreement on this assumption that have probably been completely disattended by the IP system and the pharmaceutical industry. You know, using the language of property rights, making presenting the violation of a vaccine, sorry, not of a vaccine, the protection of a patent as piracy, has really played within the idea, the mindset of many people, especially, and I make reference to the US because the US has been one of the countries that has most pushed for the TRIPS agreement. And I think that this is quite important. But also the second assumption that we have given somehow for granted, that was given for granted when the TRIPS was adopted, is that by disclosing the patents, we would enable countries to we would enable transfer of technology, we would enable innovation, invention to progress. But this was worked quite differently from how it was originally thought, and exactly because of the way of the TRIPS agreement was constructed and was framed. And yesterday we had a great conversation with some of my colleagues, and there was a specialist on IP rights, Professor Torremans, who was explaining how different IP protection in the US actually is. That IP protection law in the US requires the disclosure of the innovation in great details. This is something that is not provided for fully in the TRIPS agreement, but please, Sharifah and Amaka, correct me if I'm wrong. But also the fact that whereas previously patent protection laws required the invention to be worked in the country that was granting the protection, this requirement has now been superseded by the TRIPS agreement. Is no longer necessary. And this is what is stopping that essential transfer of technology and development that is essential. And then now it's coming back to bite us when we come to the production of vaccine, because we don't have the capacity to produce more. That capacity is limited only in the hand of a handful of companies. And therefore we find not being able to really provide sufficient quantities of vaccine to cover the need of the entire world. So these were only a couple of quick things that I wanted to add to what Amaka had already said about the TRIPS agreement.
That's really brilliant, Anna. Thank you so much for your. I think it's really important to think about that because the narrative of free trade that we've kind of been given by sort of the kind of orthodoxy of trade policy and law is this notion of free trade that goods and services have to cross borders, and almost like the TRIPS is almost an anomaly in that sense, right? Like it is about it is selective protectionism in many ways. I mean, we talked about this in the IEL Collective Conversations number 7 when we talked about international investment law. So if you're interested, we had a conversation about this last year, featuring the Professor Emeritus Professor M. Sonaraja, and we talked about investment law actually being this kind of way of protecting, investor kind of like global capital and wealth. And I think TRIPS it seems to be that one of it. And I just wanted to bring it back to, because we have a lot of this resonance that we're talking about this in relation to patents, TRIPS and vaccines, but we've been here before, and I wanted to bring Sharifah in because Sharifah's monograph is actually on the way. This is almost like, I think, Groundhog Day for you, Sharifah.
So yeah, so in some ways, to me, it feels very strange because it feels like, as Amaka and Annamaria talked about, we're rehashing the same arguments that we have had before around patents, which we had for ARVs before, and now we're having for the COVID-19 vaccine. So I think that's interesting to contextualize it both as a historical argument, so this is not new, although it feels sometimes like it's new because of the way in which it's being presented. So my feelings about the TRIPS waiver are largely positive. So as Annamaria says, I see it as a positive thing. So it's really good that we are re-asking in some ways some of the questions around patents themselves. But I worry that we have slightly gotten sidetracked by the waiver agreement, because just by the USA agreeing to waive the patent doesn't mean that it's happened. Of course, we know that the WTO acts through consensus. So it means that all countries must effectively agree. So this is a first step. It's an important first step, but we must convince other countries to get on board. And that is really difficult because there's a lot of division amongst the other countries. The second thing for me is time. So as Amaka pointed out nicely, this began last year in October, and the last TRIPS agreement waiver took over 2 years to agree. And so in the midst of a crisis, we need to really think about the temporality of legal agreements and how feasible they are to agree within a pandemic. And I think that that's something that we need to, I think, take seriously. And then finally, even if we could agree that TRIPS agreement waiver, my worry is that we are constantly weakening the language of the TRIPS agreement waiver. So we were really excited about the USA agreeing. But one of the things that most of us have noted is that the USA has already weakened the language. So it's moved now from vaccines and technology to just vaccines. And my worry is that in the process of trying to have this waiver, because we are so interested in the waiver as the outcome, that we weaken the language even further. And so we get less and less things around what we need for vaccine capacity just through this negotiation process. And so as activists and people who are really interested in this, we need to be really alert to the questions that we are asking in terms of the process. And if we really want to be radical, we also need to still, as Annamaria talked about, be questioning the process in its entirety. Do we really need this TRIPS regime? Is it fit for purpose, knowing what we know now? So one of the basic tenets of this is that it helps innovation. But many of us in the global north know that our countries have paid quite a lot for this innovation, so it hasn't been free. These companies haven't done it from the goodness of their hearts. We have paid them money, we have given them space, we have given them tax concessions, we have helped them in planning. So all of this is state aid that goes to an industry that claims that it is doing a lot for innovation. And this is something that I think we need to really question at this point and take critically going forward. And there's kind of many other things about the implications that I could say within developing countries, but I think that for me is the process. These are the critical questions that we really need to be asking at this point.
Thank you, Sharifah. And I think one of the things that really dovetails with this whole issue of I guess, pharma and, big pharma and patents is also the whole financing of global health, which is, something that you and Amaka work on, which is a completely different thing. It is dominated by certain voices, certain philanthropy, and again, that enmeshment of, private actors, private philanthropy, global capital, and patents really is such a mix. And it's like you say, we can't just, we're putting all the eggs in kind of like a legal basket about waivers, and it's a nice thing. And I wonder also, in my kind of very cynical mind, whether that's, in a way, a very good strategy by the US to kind of say, like, right, we concede on that, so everybody let's focus on this one thing, which is the waiver on vaccines, and we're going to concentrate on just, that kind of negotiations. And I just wanted to bring Tara in now, because Tara works on business and human rights, right? And I don't want to just kind of push it on you as the kind of honorary US citizen here to talk about the US proposal, but I am. So, I'm gonna, sort of get your views on this, and also the kind of like the complexities of this kind of regime that we're talking about in terms of, drug development and technology and capital, global capital, right?
I mean, Sharifah did a really nice job there of highlighting how the US has manipulated this discussion, really, and turning it into a question of patents for vaccines only, right? We're not talking about technology transfer anymore. We're not talking about trade secrets anymore. And what that means is that for certain drugs, there's potentially a little bit more leeway, right? Like if you want to try to sort of work around the AstraZeneca stuff, you can sort of kind of get there over time. But the mRNA drugs, I mean, those vaccines, they're going to be completely, it's going to have very little relevance to spurring on new technology transfer. It's going to have very little relevance to ensuring that those drugs, the Pfizer and Moderna drugs, are getting out into populations that could benefit from them. And for me, okay, so there's several reasons why the US approach this makes me angry. And I appreciate that the US approach is probably coming from a combination of an intentional manipulation of this conversation and good-hearted intentions by certain members of Congress, right? Like, you know, when AOC comes out and calls for a patent waiver, I believe that she's not trying to manipulate the system. Maybe that's just because I love her. But I also think I think that there is a recognition within a certain sector of the US political landscape that we need to really revisit TRIPS as a whole. And really US taxpayers, when we talk about the financing of these drug developments, US taxpayers should be angry about TRIPS, right? We pay so much money for drugs because of how they're protected from a patent perspective. And we end up financing a lot of the research and development, not just through our formal subsidies and grants, but also through how much we pay for drugs and how that's then used for research and development for other drugs. So we're essentially financing a significant amount of research and development by buying things for like insulin, right? Like insulin that has been around forever and we shouldn't be paying excessive amounts for. We're now being asked to pay like $300 for a couple of EpiPens. And then that money is being used by these companies to develop stuff that they then use to exploit elsewhere, right? So it's this sort of weird cycle in which US taxpayers are financing these drug developments in multiple different ways, and then we get none of the real benefits from it, because as I think it was Amaka who said, you know, we're never going to progress in fighting COVID and returning to sort of pre-COVID normality until we actually have global herd immunity, and that's right. And so we're doing this in this way that's really just servicing these large multinational corporations. And the other reason that it makes me angry is because it's just massively hypocritical, right? In 2001, the US had 5 deaths from anthrax, and we threatened to do compulsory licenses for anthrax medications at that moment, right? So 2001, we have 5 people die, and the US is like, screw TRIPS, we're done. Let's do compulsory license so that we can make sure our entire population is covered and has access to anthrax medication. And now we're seeing this global pandemic. We're seeing India document over 3,000 deaths a day, and that's probably underreported. And the US approach is, we'll give you a tiny little bit of access to what we were perfectly willing to do for ourselves. And I think there's something really deeply hypocritical there. It's also really dangerous because of how the US is willing to enforce TRIPS. And when I say the US is willing to enforce, I don't just mean for US companies, right? So several years ago, Colombia wanted to use a compulsory license for a drug from Novartis, which is a Swiss company. The US has no interest in protecting Novartis's drug manufacturing or its patents. But the US members of Congress and the administration, it was the Trump administration, but I think it was the Trump administration, but I think it would have been true under the Obama administration and under the Biden administration as well. They actually threatened to stop supporting Colombia's peace initiatives, right? So in order to protect Novartis's patent. And so the US actually does robustly enforce these agreements, not just for their own companies, but sort of as a global police for patent rules. And when the US does that, it does carry more power, you know, than if Barbados decides that it's going to try to enforce patent rights against the US. So this retaliatory nature of a WTO system enhances the US's capacity and capability to force other countries into doing stuff that just isn't in their interest. And it really puts it's disproportionate pressure. So there's that added danger. Now, I am going to say for the US's, this is the one defense that I will say, is that the US's position is still more lawful as a matter of international law than the positions of Australia and the EU in opposing the waiver. And that's because the US isn't a party to the International Covenant on Economic, Social, and Cultural Rights. The US isn't a party to that covenant because it protects things like the right to health and the right to education, and it would completely overthrow the neoliberal economic order of the United States. So we don't bother with it. But what the Covenant on Economic, Social, and Cultural Rights says, it's a few things. First, it does recognize a right to health. It also recognizes a right to benefit from scientific progress. So we recognize that there is a sort of inherent matter of human rights there is a human right to benefit when science develops for the sake of society. So we should be benefiting from this mRNA technology. We should be benefiting from AstraZeneca, and that is a fundamental human right. It also requires states to engage in international assistance and cooperation. That's one of the core obligations under the covenant, is for the realization of all the rights within the covenant, states are supposed to work together. They're supposed to engage in technological assistance and cooperation. So we should see, from a human rights law perspective, a lot more technology transfer than what we're seeing. We should be seeing a lot more development and knowledge exchange. We should be limiting these trade secret protections. And now the US isn't a party to any of that, so it has no obligation to seek international assistance and cooperation in this regime from that particular legal perspective. But Australia and the EU are a party to it. A lot of the other countries that are dragging their feet on this are a party to that covenant. They do have this obligation to work for better and more cooperative approaches to fighting COVID. And that carries not just domestic obligations, but that international assistance and cooperation obligation is extraterritorial. We know that. We know what it involves. We know that it involves not just stop interfering with the development of progress that is going to be helpful, but it also requires a regulation of these corporations to stop them from abusing the patent protections. And we're not seeing that either. And I think, I'm sorry, I know I've talked for a really long time, but I do want to say that I want to highlight the danger that comes from robust enforcement, because I don't think people fully, I think sometimes people don't fully understand what the implications are. But we're seeing in the United States right now, Pfizer, BioNTech, and I think it's Regeneron, who are right now facing a US patent lawsuit. So it's not under the WTO, but it is under US patent law, and they're being accused of abusing a patent and using for commercial gain in the development of their COVID medications, testing and treatments. And when you think about that, what that means is that this other company, it's ALLELA or ELE. Anyways, that company, however you pronounce their name, that company could have prevented Pfizer from developing its vaccine, right? By setting conditions for how Pfizer could use their fluorescent thing. I'm sorry, this is where my technology and science ends. There's some fluorescent thing that they needed to use for testing. And so what you could have had is this Pfizer vaccine that we're relying on so heavily may have never actually, or may have never been developed, or it would have been developed in a less efficient manner. So we would still be waiting for it now if these patent protections had been preemptive the way that TRIPS is preemptive in its role. And I think that there's a real danger in that. And I think people need to understand that this isn't just a thing. It is a thing that right now disproportionately affects the Global South. And it's something that we need to be really cognizant of how US power is being used in the service of profits at the expense of whole countries and whole continents. But it's not just something that affects the Global South. And American taxpayers should be angry about how, not just American taxpayers, like Americans full stop, like I don't care if you avoid taxes. You should be angry about how this is playing out, about what our government is doing in this situation, because it is quite manipulative. Sorry, that was a massive rant.
That's all right, Tara. I just wanted to give the floor to Anna before she has to pop off. But Anna, just in terms of the EU's position, because we've talked about, you know, sorry? Like from that, yeah.
Just in terms of what?
The EU's position, and also what do you see in terms of, yeah, the negotiations going forward, and what did you know, what are your thoughts on this?
Can I say something else instead? No, before the EU position, I just wanted to say something that while Tara was talking, I realized how I was tuned with my trips here on, And when Tara was saying there is a right to scientific benefits and to benefiting from scientific innovation, I automatically thought about the rights of the companies to benefit from their own innovation. I didn't think, then only later on I understood that, of course, it's the rights of everybody to benefit from that innovation. But it's amazing how if you're attuned with something, so if you're attuned to something, you keep thinking about that. And I just wanted to say about that, of course, this is the narrative we have listened to for a very long time. And we need to remember this, the fear. And I think that's why, to many extent, justifies why not many people are angry about this, because there is a fear that unless you protect, you're not going to have innovation, you're not going to have investments. But there is nothing more wrong about this. That this is probably the biggest lie about TRIPS. And also the fact that we are not rewarding investment made by private individual only. We are rewarding investments made by states, by the state. Most of this vaccine have been financed through state investments, and this is something that we need to remember. And the one more thing that I wanted to say is linked to procurement, because this is my specialist. But in order to many of these companies have had investments also in the form of advanced purchasing agreements. So they've had their assurance that there were some countries ready to buy what they were producing. And this is something quite significant. And this is a privilege that these companies have been granted. So this is something that I really wanted to flag up as well, that often we forget, but we're talking about billions of advanced purchasing agreements that have been made in favor of these companies. And very often, and at least it happened in the case of the H1N1 pandemic, developing countries haven't been in a position to be able to agree these advanced purchasing agreements. So this is a further disadvantage that developing countries have. Also, something else that I think is quite relevant is that even when facilities have been provided by the World Health Organization to provide some sort of vaccine deployment initiative, for example, also in the case of the previous pandemic, the flu pandemic, developing countries have had to show that they were able, not only that they wanted to take part in this initiative, but also that they were able to provide a waiver for the companies to waive them from any responsibility that might incur in the administration of the vaccine. And not many developing countries have got the funding to do so, and this has been a great barrier. But also developing countries have had to show the capacity to distribute the vaccine. And this capacity requires a good health system. Most developing countries haven't been prevented to invest in welfare system and healthcare system because of the rules that financial institutions have imposed on them. So I think that really there is a need to reconsider the entire system in a more holistic way. For the EU, I've got, unfortunately, the EU position is bitter. The way I am against the EU is very bitter. The EU has just started legal proceeding against AstraZeneca, the only company that has that is sourcing the vaccine on cost. I think this is, very disappointing for all of us. The Pfizer vaccine costs are around 15 to 18 pounds per doses. The AstraZeneca costs £3, and yet the EU is suing AstraZeneca. And I think if we say this, we say it all, for not mentioning the fact that it's not supporting the waiver, is delaying things. It's appalling as a position, really. But I've taken up even too long, and I saw that Sharifah as well has to go. So
thank you, Anna. Thank you so much. So yeah, I just wanted to pick up with Sharifah actually. Tara talked about the right to health, right, and the US not being a party to the International Covenant on Economic, Social, and Cultural Rights. And I know that you've been also looking into the issue of how vaccines can be distributed based on a rights framework. So I just wanted to come back and ask you a little bit about that.
Yeah, so absolutely. So the EU is not a party to the International Covenant on Economic, Social, and Cultural Rights, but it's a party to the international health regulations. And those also include some basis for, so they have a normative basis for human rights. They clearly state in the preamble that human rights approach will be used in order to interpret it. And so if you're thinking about human rights and stopping a pandemic, that for me is a very good segue into thinking about their rights obligations. But also Article 44 of the IHR again talks about a duty to assist. And so this is not only in economic, social, cultural rights covenants, it's also within the IHR, which has been promoted largely by the USA before this point, because it wanted to stop some kinds of pandemics. And so I think that that's worth pointing out. So I want to also then go back to something that Annamaria was saying. So in some ways, for me, one of the interesting things about the development of this, of the COVID-19 vaccine, is how little risk pharmaceutical companies took. They took very, very little risk in terms of research and development. They took very little risk in terms of production because of advanced procurement. They took very little risk in terms of the side effects of possible vaccines, because we have either given disclaimers so that we will not sue, or we have actually asked for some sort of insurance schemes by countries, so that at every level, these companies are just kind of getting rid of the risk within these systems. And so this feels to me like it's the perfect storm for somebody to make a product with really very, very little risk. And I think that that for me has been a really interesting thing to think about in terms of this crisis that we also really ought to be aware of. And for very many developing countries, that has also continued in that some of them have had to take on further debt, not only to buy the vaccine, but also to give assurances to corporations that they will pay something in case these vaccines have side effects. And this is just like deeply problematic on any level. And I think it's something that we really need to pay attention to when we are thinking about the so-called ideas of innovation that are inbuilt into the TRIPS agreement.
Thank you, Sharifah. And I think this conversation can go on and on, because there's so many issues to this. It's about the financing of vaccines. It's about international assistance. It's about the fact that at the same time, you have austerity budgets coming in because they're being imposed by the international financial institutions, and the conditionalities that come attached to that. It's very, very different from the expectations, that countries are expected to have and to have to meet. And so I just wanted to bring Amaka back in to this conversation with regards to also the issue of financing, which I know that we talked about and looked at, but also in any way to respond to points that have been raised by the other speakers.
Yeah, so one of the things, so after I finished my PhD, when I was doing my PhD fieldwork in India, Brazil, and Nigeria, one of the things I kept picking up was the role of philanthropic organizations, And even though my PhD did not focus on that, and the book that came out of it didn't focus on that, I'm now working for the past 3 years on philanthropic actors, social financing, and how they shape international economic law. So when the whole Gates thing blew, it's still blowing up, I was finally like, yes, people are beginning to talk about this because it's important. But one of the questions I keep hearing people say is, so how did the philanthropic actors get so deep in with public health, and how are they shaping and framing global policies regards to public health. And now we are seeing it in intellectual property law and stuff. But I think we have to go back to history and see how certain policies created a gap that made it possible for these actors to step in. So if we're looking at the structural adjustment program and how the austerity measures imposed on many countries in the global south shrunk, or in some cases actually devastated the health sector, and then created a vacuum for a need for a savior to save this so-called, to save in quotation mark, many people in the developing world. And then that is how you have actors like the Bill and Melinda Gates Foundation take this really prominent role in shaping global health policy. It's not to say that philanthropic actors have not existed in some shape or form previously. They have. If you look at the Rockefeller Foundation, if you look at the Carnegie Foundation, they have been there since the beginning of the 20th century, right? But the position and the position and the power being wielded by actors like the Bill and Melinda Gates Foundation did not happen out of a vacuum. It's we are beginning to see it is a reaction to the laws and policies pushed by organizations like the World Bank and the IMF in the 1980s, that the ripple effects, we are still feeling it at the moment, right? So as you mentioned, and also Sharifah mentioned on austerity budget and conditionalities, we are creating vacuum that we are not even going to see the impact up, not now, but more like in 20, 25 years, when God knows who is going to step in to fill this vacuum. Now, maybe we're going to see pharmaceutical companies shaping global policies with regards to pandemics and access to medicine, especially as scientists have told us that we are going to be seeing more global pandemics like this as a result of zoonotic spillovers, right? So I think with the situation we have now, the question is, what is the role of law? What can we do to, in a way, claw back the power we've given these actors that are not even accountable to anybody? They're not accountable to international courts. They're not accountable to any international organization. They're not even accountable to global citizens. They are not accountable to anyone. So what are we going to do now to claw back this power from them? And what we can do, right, is to use the situation of this pandemic to start questioning who are invited to the table to be part of a conversation with regards to access to medicine, in regards to access to COVID and vaccines, in regards to intellectual property law. I was reading a piece a couple of weeks back, and I saw that in the meeting with regards to COVAX, the Bill and Melinda Gates Foundation were one of the actors that were present in almost over 15 meetings with the WHO and COVAX. Like, why are we having that? So I think going forward, we need active citizen participation, which has been going on. But the good thing is now we have social media to amplify a lot of voices, to remove gatekeepers, and also to bring in voices and opinions and views and experiences from people in the global south. So we can have activists working on ground in places like in South Africa, in places in Egypt, in Bangladesh, telling us, for example, Bangladesh has strong generic pharmaceutical sector, right? Why weren't they involved with discussions on COVAX and how to transfer technology to them so they can start producing? Why weren't they involved? So I think going forward, this is one of the things we need to start doing, like bringing more people, especially people from the global south, and also start making laws, or rather start questioning, not even making laws, or start questioning who is speaking and who are they speaking for, right? Because as you can see, even though the philanthropists that were involved in negotiating COVAX, they weren't speaking for the people, because if they were speaking for the people, the issue of intellectual property would have played a prominent role, in the sense that the fact that IP does impact access to medicine, that should have been forefront, but it wasn't. And one last thing I would also like to say is this: IP is not the only issue, right? As we've seen, there are other things or other important factors like transfer of technology and sharing knowledge, know-how. One of the things TRIPS doesn't do is to strictly stipulate that methods or processes are delineated in explicit. You get the point what I'm trying to say. But the thing is, pharmaceutical companies, even when they file application for patents, they don't list all the processes, right? They still keep some things to themselves, and it's not supposed to be that. And there is nothing in TRIPS to checkmate that. And then finally, there is the issue of undisclosed test data. So you have companies like Moderna saying, oh, we're not going to enforce our intellectual property law or intellectual property rights. However, they have not released the test data they use in the making of their vaccines that would allow other companies in places in Mexico, in South Korea, in Bangladesh to start making these drugs. They have not released it. Yes, they might not have been enforcing their patents, but they are really holding strongly and tightly to their undisclosed test data. So, and also it's important that the language, as Sharifah mentioned, used by the US, we've seen the erasure of therapeutics and diagnostics, right? The comment from the USTR is only on COVID vaccine, but the TRIPS waiver mentioned therapeutics and diagnostics and undisclosed test data, and all these things are missing from the USTR comment. So as Annamaria mentioned, we have to be aware of the language, the erasures that is going to be happening in coming weeks, the flipping and the obscurities, just so that that will lead to a watered down version of what Brazil and India presented. Sorry, it's India and South Africa presented at the WTO.
Thank you, Amaka. And I think what you raised was quite a, so in doing this whole conversation about waivers and certainly the narratives that have been peddled, one thing that really struck me was also this going back to this, I hate to say this, but a very white savior complex about vaccines, right? And it starts with the philanthropic organizations, but it also definitely starts with the Western countries, and the conversation about, oh, well, IP, waiving IP rights are not going to solve the issue because, look at these poor developing countries, they don't have the manufacturing capacity and they don't have the supply. And that in itself is a very it's a very demeaning narrative, right? Because as you rightly point out, Amaka, that developing countries have been at the forefront of producing. I mean, India was producing vaccines for distribution under the COVAX, under license. Lots of developing countries have that capacity. So it's almost like that there is a vaccine imperialism. I think that's that is the word that's been used, right, by activists, but also by other scholars, that it's problematic. And I think one of the things that we did establish today is that the narrative needs to change, number one, and secondly, it is not just an issue of law, it's about economics, it's about business practices. And and it's more about this conversation about the structures of the global economy and the underpinnings of it, which goes back to our other conversations about the legacies of colonialism and slavery within law in the global economy. And Tara, I know that you've worked on this area as well.
Yeah, no, I mean, I just honestly, Amaka, everything you said about the Gates Foundation was so spot on. One of those things that I think gets really overlooked is how Bill Gates is able to manipulate the conversation to make it sound as if without him, we would make no progress whatsoever in global health, right? And his Sky interview was really clear about that, right? He's saying, without me, without my foundation, these factories in India would never have been able to produce a vaccine like the Johnson & Johnson vaccine. And it's like, well, actually, we have a history of companies in the global south proving that they can do this, right? If the constraints are taken off of them, if they're allowed to do it, they can do it. But it's deeply racialized. And I think we need to call it out on that. We need to call out Bill Gates. We can have a whole other thing about how evil Bill Gates Foundation, the Bill and Melinda Gates Foundation, is more generally. I don't want to go too far into that because I do realize that it has the potential to sort of boomerang back into the conspiracy theories around the vaccines, and I don't want to get into that. But I do want to say that we need to acknowledge up front that it's racist, that this this belief that scientific progress will always stem from Western development plus Western philanthropy. It's there's no basis for it, and it's racist. It's steeped in historical narratives around race and white supremacy, and if we don't call it out for that, then I think we're doing a disservice to the discourse.
Thank you so much, Tara. I'm also aware that we should keep our conversations to time, and we've had so much to talk about, but I think that's another IEL Collective conversation, right? To bring other people on board. So to our audience, if you have something to say, please, or you have some a comment or idea for another collective conversation, please email us at the email address, Twitter handle that we can see somewhere in the screen. Yeah, we look forward to having more of these conversations and reviving our collective conversations. Thank you, Tara. Thank you, Amaka. And thank you to Sharifah and Annamaria. And what a amazing all-women panel we convened today.